ERCS has a campaign to establish an environment court. We think that setting one up could increase accessibility and affordability. It could help to develop judicial expertise, and ultimately it could achieve better outcomes for people and the environment than our current system. In my few minutes, I'm going to focus on affordability, and I'm going to touch briefly on the politics of an environment court in Scotland. Now, no surprises, I'm sure, for most of you to hear that going to court over the environment is unaffordable for most people in Scotland. Many people that we've given legal advice to have had cases with merit, but they've been deterred from taking legal action purely for costs reasons. The odd case will get through with a protective expenses order, with some pro bono support, or even exceptionally with legal aid. But in general, environmental litigation in Scotland is like polo or grouse shooting. It's a pastime enjoyed mainly by rich people. The reason for this is largely the forum where most environmental disputes are heard in Scotland. That's the Court of Session. The Court of Session is the highest and most grand civil court in Scotland, and litigating there requires expensive legal representation from advocates and solicitors. And the general rule is that if you lose your case, you have to pay your own legal fees and those of your opponents. So that kind of heady brew of expensive representation plus adverse costs risks means that the final bill for going to court over the environment can be well into the high tens of thousands, and it's not uncommon for it to reach six figures. But what does it say about our democracy if laws passed by Parliament to protect the environment can't be enforced by citizens and can just be ignored with impunity? The founder of Client Earth, James Thornton, I think puts it quite nicely when he says, if you pass an environmental law and you don't enforce it, then effectively you authorize the conduct that you sought to prohibit. But why do we have this deeply unsatisfactory state of affairs? The answer, I think, is politics. Our justice system is not some sort of untouchable architecture which has been designed on high by a divine judicial being. Like all human systems, it's an institution which reflects political choices, and we see that most clearly from who it benefits and who it disadvantages. We know who it disadvantages, but in terms of who it benefits, unaffordable legal costs shield unlawful activities from legal challenge. The status quo in Scotland effectively protects our government and public bodies from being held to account and from being embarrassed in the courts. Which leads me to this consultation on the slide. Last summer, the Scottish Government consulted on the effectiveness of our environmental governance arrangements. And that consultation was arranged as part of a post-Brexit checkup. It was supposed to consider the question of whether establishing an environment court would improve environmental governance. However, the report dismissed the need for an environment court over just 5 paragraphs of text. And when I read it, I was left thinking that the Scottish Government did not really give the matter any serious consideration, and perhaps the result of that consultation was predetermined. And if you don't believe my ravings, I encourage you to read the opinion we commissioned from Prof Campbell KC on the legality of the consultation, which you can read on our website. John concluded that the Scottish Government failed to discharge their legal duty to properly consult over an environment court. And I want to finish with 2 examples of specialist judicial bodies in Scotland, just to reflect on the status quo that we have at the minute. First, we have the Court of the Lord Lion. When the Lord Lion is not busy parading in a feather cap or congratulating members of our society on titles, he presides over the registration of new coats of arms and hears disputes over coats of arms. So just to repeat that, Scotland has a specialist court that hears disputes over coats of arms. We also have the less prestigious General Regulatory Chamber of the First Tier Tribunal for Scotland. Last June, this tribunal was given jurisdiction to hear appeals against penalty notices for things like breaking parking rules and driving in bus lanes. Now, I'm not saying that any of the subjects dealt with by the Court of the Lord Lion or the General Regulatory Chamber are unimportant. It's probably a good thing that heraldry disputes are heard by experts in what must be a complex field. But what does it say to have a society that values the need for specialist expertise to resolve heraldry disputes, but not for the environment? What are the priorities of a justice system which allows citizens to challenge overzealous traffic enforcement without the fear of ruinous adverse legal costs, but citizens are priced out of going to court over the environment? Needless to say, it doesn't need to be this way, and many other countries have organised their affairs in a much better way. There are specialist environment courts and tribunals across the world which Scotland could learn from. And we're now going to hear about one of them from a very experienced and highly regarded judge whose work puts him at the centre of a very different system to ours. The Honourable Justice Brian John Preston SC is the Chief Judge of the Land and Environment Court of New South Wales. He was appointed as the Chief Judge almost 20 years ago, and prior to that, he worked as a solicitor and barrister. Brian was the first solicitor of the Environmental Defender's Office in New South Wales when that was set up in 1985. The EDO, if you haven't heard of it, is quite a similar organisation to ours and one that we took a lot of inspiration from when we set up ERCS. Brian is an industrious author and judicial speech giver. He's constantly published in academic journals, including a recent article on the right to a healthy environment in the Journal of Environmental Law. He's written widely on specialist environmental courts and tribunals, on climate-conscious lawyering, and one of my favourites, on writing judgments wildly. Brian's writing on this topic on environmental courts has inspired our thinking. And you can see that clearly from the many footnotes that we have citing his work in our reports and our briefings. Brian, over to you, please.
Okay. So look, it's a great pleasure to be able to join you for this presentation. I've a special fondness for Scotland. We've visited a number of times, including at the University of Dundee, and my wife and I ancestry comes from Scotland, so it's great to be able to participate, even if it's only virtually this time. So I'm going to share my screen here. And hopefully that's all ready to go. So you're looking at the need for a so you're looking at why Scotland needs an environment court, and to get to some assistance, you're looking at asking me to present about a court in the other side of the world, the Land Environment Court of New South Wales. There's a reason for this, is that the Land Environment Court is the first specialist environmental superior court of record in the world. So it was established in 1979, it started operation in 1980. But how can we evaluate the legitimacy of this court? I mean, if it is a court to be used as a model, then we should critically evaluate its legitimacy. Professor Gary Warnick from the University of Otago in New Zealand has written a book which argues that the legitimacy of specialist environmental courts can be measured by evaluating their responsiveness to the environmental disputes they are established to resolve. It's about fitness for purpose. She says there are four components of responsive environmental adjudication. The first is to identify the very problems that are the subject of dispute and that need to be resolved. And these are environmental problems. And so the courts need to identify those distinctive characteristics of those problems. The second is to acknowledge the impact that those characteristics of the environmental problems have on the law and the resolution of disputes, and in particular, what challenges they create for adjudication. The third is to develop environmental law doctrine, procedures, and remedies that are responsive to those challenges. And the fourth is to identify and implement the particular adjudicative forums and functions which will facilitate the adjudicative process. And this includes establishing courts with particular constitutions, competences, and expertises that are better able to respond to and resolve environmental problems. So come back to the Land Environment Court. So it has an institutional design which better enables it to engage in responsive environmental adjudication in the ways that Kerry Warnick suggests is needed. And if we go through what the Land Environment Court does and exhibits, it shows that it has got all of the characteristics of successful environmental courts around the world. And there's an article I wrote about 10 years ago in the Journal of Environmental Law, where I tried to evaluate what makes a successful environmental court and what are those characteristics. And I came up with a dozen, and the Land Environment Court exhibits that dozen. But it's one thing to design an environmental court with a constitution, competences, and expertises which will better adjudicate environmental disputes, but it's another if that design is not operationalised. And so what we need to see is that the Land Environment Court has operationalised its institutional design. So this requires the court in practice to achieve those characteristics that Kerry Warnick has identified of responsive environmental adjudication. So I want to, for the rest of the short presentation, is show you how the Land Environment Court has done this. So one of the things that the Land Environment Court has done is to develop environmental legal doctrine, procedures, and remedies. And the court's decisions have developed aspects of, and I'm going to give different aspects of justice here: substantive, procedural, distributive, recognition, reparative, and restorative justice. So I want to unpack each of those and just show you how it is that the court's decisions have done that. So let's start with substantive justice. So this is involved with the distribution of environmental goods and bads, and how that is a fair and just distribution. So the court has developed jurisprudence on the principles of sustainable development. We call it in Australia ecologically sustainable development, and they include many that you would be familiar with, like the precautionary principle, the principles of intergenerational and intragenerational equity, the principle of the conservation of biological diversity and ecological integrity, the broader principle of internalization of externalities or external environmental costs, and that includes the polluter pays principle and the user pays principle. The courts developed extensive jurisprudence on environmental impact assessment, but also in relation to sentencing for environmental crime, because unusually the Land Environment Court has criminal jurisdiction as well as civil jurisdiction. But what about procedural justice? We can think about the Aarhus Convention or the Rio Principle 10, the threefold rights of access to environmental information, public participation, environmental decision-making, and access to justice to enforce these substantive and procedural rights. So the court has made many decisions which uphold those rights. But importantly, and flowing on from what Ben Christman said, is the court has lowered these barriers to public interest litigation. One way is to broaden standing to sue, to allow any person to bring proceedings to remedy or restrain breach of the laws. Its second way has been to not require an undertaking for damages as the price for securing an interlocutory injunction. A third is not requiring upfront security for costs, which can be crippling. The third is not to worry about the doctrine of laches and summarily dismiss proceedings for that delay in bringing the proceedings. And the final, which is the point that Ben Christman made, is not ordering the payment of costs of unsuccessful litigation which is brought in the public interest. Now come to distributive justice, and as I said, that's the distribution of the environmental benefits and burdens between people and groups. And the court has been able to develop distributive justice by upholding those principles of intergenerational equity, so justice between generations, but also intergenerational equity, justice within the current generation, by applying the polluter pays principle, which gives intra-generational equity, and also in involving a balancing between the public and private rights and responsibilities. But substantive and procedural justice are insufficient. There also needs to be recognition justice. That is, recognition of all people, including marginalised and vulnerable individuals and groups. And in Australia, Indigenous people, the Aboriginal people of Australia. And that can be done by facilitating access to the courts, by opening standing, by allowing intervention in proceedings, including by amicus curiae, by adapting the court's procedure to allow, for example, evidence to be given on site where people feel comfortable, or for Indigenous people to be able to give it on their country. And then we come to the concepts of reparative justice and restorative justice. So reparative justice, the court has been innovating and imaginative in crafting remedies for breaches of planning or environmental laws and in sentencing for environmental crime in ways that seek to repair the harm that's been caused by the breach or the offence. That includes implementing the polluter pays principle, but it also includes implementing ecocentrism. That is, the environment is a victim that needs to be compensated or the damage to be repaired. And then we come to restorative justice, which is different to reparative justice. So this is looking at how to restore the victims and the communities that are affected by the commission of offences or environmental or breaches of statutes. And so those restorative processes can include a victim offender mediation, and that has been done in the court, particularly with offences where the victims are the Indigenous people of Australia. But beyond developing justice, the courts has also developed environmental governance. It's improved governance by both the government and the private sector. That has been done with respect to the principles of ecologically sustainable development. It's been done in relation to social impact assessment, but importantly, it's been done in relation to climate change governance. So the court has developed these principles of ecologically sustainable development, and these have led to a change in the way in which the executive arm of government assesses, approves, and implements activities that impact on the environment. So the court, for example, has developed the precautionary principle, and I give one decision, it's a decision of mine, back in 2006, which has been cited and approved, but also distinguished throughout Australia and has been implemented by government in environmental governance. The court has developed the concept of social impact assessment, and that has changed the way in which government assesses, approves, and implements activities that impact on communities, groups, and individuals. But importantly, I think the court has changed the way in which government and corporations govern in relation to the planetary crisis of climate change. So the court's decisions have influenced climate change government and litigation, both in Australia and overseas. And one example is a decision of mine in the Gloucester Resources and Minister for Planning case, or the Rocky Hill Mine case. And that's been referred to in Australia, in Canada, and the United Kingdom. So in a very quick overview, I've tried to show you how an environmental court can make a difference. It can respond to the environmental problems and challenges of the time, and it can deliver environmental justice. And the example is the Land and Environment Court. It is a successful court. It's been operating now for 43 years, and it has achieved responsive environmental adjudication in the ways that Kerry Warnick has said. And amongst other achievements, it has improved access to justice in those different ways I've explained, as well as environmental governance. Thank you.
Thanks very much, Justice Preston, for your very thought-provoking presentation there, which hopefully will give us a lot to think about in Scotland, a lot to draw on there from your experience. We're now going to move to our second speaker before we come to questions. And just a reminder to please put your questions in the chat as we go along, and I'll field them at the end. Our second speaker is Professor Campbell Gemmell. Campbell has asked me to keep my introduction short and sweet, so I'll try and do that. He is currently an expert advisor on environmental regulation to the OECD. Campbell is an ERCS stalwart who in the early days was our chair and is now a trustee. Campbell has written widely on environmental governance and on the need for an environment court in Scotland, including his report for ERCS, The Clear and Urgent Case for a Scottish Environment Court. In that report, Campbell told us that the time has come to move on with some urgency from why to how to define the best current form of the court and progress to its establishment. I think Campbell's going to be talking, is going to give us a mix of the why and the how. And over to you, please, Campbell.
Thanks very much, Ben. I hope you can all hear me okay. Good afternoon, everyone. Good evening to Brian. In honour of Justice Preston's involvement and the wise peoples of Australia, and in honour of country, I'm wearing my water dreaming tie, so I hope that gives us a good connection. And really good to hear both of the contributions so far, and I hope I can just add a little to the narrative. In some presentations that I've done on this subject, I have included an image of a certain North American animal, because it feels as if there is a groundhog relevance to some of this, in that we have been round the block, as perhaps Brian was suggesting, given origins of his court 40 odd years ago. We've been round the block a few times. And it raises some interesting issues, highlighting to start with my more recent report for ERCS back last year. But there have been contributions for 40 years and more looking at the need for, the benefits of, the case for a court in Scotland. There have been lots of studies and reports on governance and its needs and where a court might fit within that. Wide recognition that good governance has this triad of oversight, including Parliament, effective executive control, making sure that regulatory and other efforts are delivered effectively, and then also, thirdly, those robust juridical processes. So those three components. And in the Brexit narrative, I will use that B word, we've gone through the loss of the Court of Justice of the European Union and the European Commission and its various component parts, including the European Environment Agency. And together, those elements have effectively removed 2/3 of that relevant structure, arguably, certainly at the peak level. And whilst we have created Environmental Standards Scotland, and that's good, it's only a partial substitute for one element. In the 2019 report that I did for Scottish Environment Link, we identified 4 system elements. Working with a range of colleagues, we put this together. We articulated that there was a need for a coherent integrated system in Scotland. We had components, we did not have a coherent system. We highlighted the need for an environment court. An independent parliamentary commission or commissioner was identified, partly learning from the New Zealand example. And we suggested a review and reform of existing governance. The gaps thus far are pretty clear. We know what we have lost, and we also know that there has not been the creation of a parliamentary commissioner, although we have created ESS, and there has not been any kind of review or reform of the existing governance of relevant Scottish bodies. We also know, and again, excellent to hear Justice Preston describe the New South Wales Land and Environment Court, ECTs exist widely and seem to function variably, but well, and they are valued, especially if they are suitably framed, empowered, and resourced. And Ben modestly didn't refer in any detail to his report on why Scotland needs an ECT, and a lot of really useful material is contained there. There have also been Scottish Government consultations and commitments to merge the 2 existing relevant bodies that could be part of an ECT world. We await actual development on that front. And we have an issue around acknowledgement by the system of that which ERCS's experience has highlighted, that there is heavy constraint around access to justice. There are several different barriers, including the levels of awareness and knowledge, access to information, the approach to standing PEOs, etc. And very clearly, an asymmetry of power overall, a long history of an asymmetry of power. And in the Aarhus context, as both of my colleagues have touched on, clear indication and recognition at an international level that there is an ongoing failure within the UK and Scottish access to justice systems. In addition, we've got a developing human rights agenda. It's maturing. We see a wider acceptance of the need for a right to a healthy environment, growing in prominence. Scottish Government is engaging with it, but we need to know how that progresses. And it is separate, but obviously potentially connected. In my 2023 report, I highlighted the various potential issues that we anticipated from Brexit, and then brought it down onto the actual post-Brexit realities. No court, no commission, no EEA, significant losses, ESS created, no other governance changes, and a backdrop of continued environmental deterioration, as well as continued difficulties for access to information, access to justice overall. So the barriers are persistent. We see new developments and new opportunities, but we don't yet know where they lead. And we have, in that report, I have articulated some of the issues around the potential fate of a court in Scotland. So, issues to tackle. Achieving those attributes that Brian described, I've called them there the Preston 12+, and the Prings and Brian have reviewed the attributes of courts worldwide. Brian set the bar in terms of identifying those key components, and why would we not want them, might be the way I would express it. That's a very clear checklist of desirable dimensions of a successful court. Building on the existing strengths and fits within the whole system seems also imperative. How do we make sure that agency and other processes are improved? Who is going to look at that? How is that going to be delivered? How do we properly balance the effort between the various ombuds persons, ESS, the nature and operations of the existing sheriff courts, the higher courts, the way in which they work, and the potential merger of the court and tribunal that we already have? And how do we achieve efficiencies and greater solutions in terms of delivery on the ground? And how do we tackle systemic and cultural benefits? How do we articulate those? Brian and others have made very clear the value of dedicated technical expertise and that broad developed jurisprudence, and we need to look carefully at the actual substantive business. How do JRs progress? What are the rules around them? How would they be incorporated within any new court model? How does escalation happen? Who is not involved in the escalation chain? Who is? How do appeals actually work? What we want is a better whole. We also need to tackle the timeliness dimension. Leches has already been mentioned. How do we make sure fair and effective remedies are achieved in the public and in the individual's interest? We need to clarify the political, the judicial, the administrative issues where there is a will but concern, or where there is not a will. And we need to consider the appropriate powers and formative and resourcing actions. And we need to acknowledge and tackle the inadequacies and gaps in the current system. They need to be socialized. So challenges, opportunities, needs. The case for such a court in Scotland seems, especially to those of us who are convinced, compelling, but there are embedded polarities. If there really is an appetite overall, what are we going to do about it? How do we move forward? If there is not, then what? Are we openly going to discuss why we think this is not acceptable? And what is the tolerable level of failure within our society in Scotland? What are we prepared to live with? There are accelerators and brakes in the system. We need to progress a campaign or a movement towards the court alongside the constitutional issues of the UK. I've used the loaded word mess. We are in an interesting time in Scotland and in the UK, elections not perhaps too far away. What does that mean to public spending, to the appetite for change, to competition over time in parliaments? And we need to look at the policy objectives around human rights, around the various other policy initiatives that are developing. How do these all come together? And we need to tackle overtly any inertia, complacency, resistance, whatever we might call it, within the establishment. And how do we encourage disempowered citizens to move forward in a constructive way? And how do we deal with the continuing environmental harms? We need to understand the concerns of those who are opposed or unconvinced. And we need to look closely and perhaps again socialize those issues around vested interest, promoting as best we can around the country the advantages of a new model. We want effective justice, we want intervention and redress as described before, and we need an expert dedicated court completing and consolidating a Scottish system. So as Ben flagged, have we or have we not moved forward to a point where we shouldn't be asking why and should there be, but we should be focused on why not, how, when. The prize, environmental justice, visible, palpable, experiential justice on a wide basis across Scotland. We want to see an enhanced system placing a dedicated expert court at the centre or top, depending on your perspective, of the whole resolution, recourse, remedy system, taking us to a stronger, fairer, more open and more complete model of environmental governance in Scotland. It would show those implementing policy or those not implementing policy. It would show those breaking the law and those seeking to have their rights upheld that there is effective oversight of the system, and they can be variously heard or held to account. It would restore a loss and address key asymmetries and allow Scotland to show itself and the world that it takes the environment, the citizen, and the law seriously. Thank you.
Thanks very much, Campbell. What a prize. Okay, we now move into our Q&A session. And Justice Preston, the first one is for you from Mark Lazarowicz. I don't know if you can see the chat. Mark has asked us a kind of multi-clause question, which I think I'll summarize as, can you tell us a bit about the rules in your court on dealing with when costs are awarded against unsuccessful parties?
So we have a complex system of cost rules depending upon the nature of the litigation. So we have, it's not, the number's not magic, but 8 classes of jurisdiction. 3 of those are criminal. And for the criminal, it's the usual rules about for awarding of costs. So I won't go into those. For 3 of the jurisdictions, they have elements of merits review. In that, the rule is that there's a no-cost rule, that each party pay their own costs unless it's fair and reasonable to make a cost order. Then we come to the class 4, which is our really our Supreme Court or your High Court jurisdiction. It's the judicial review jurisdiction, and that's where we get the public interest litigation. So there, the starting point is that it's the normal, UK rule that the successful party has their costs paid for by the unsuccessful party. But we have a special rule which allows for an exception in public interest litigation, and that is that an award of costs will not be made against an unsuccessful public interest litigant. However, it doesn't apply in all cases. The judge has a discretion as to whether to make no order as to costs. So one of your questions was, even though there is that rule, how often is it exercised, and does it still act as a chilling effect? Well, I think that the judges do use the rule. So whenever they find that it is a litigation that can truly be said to be brought in the public interest, they do use the rule to not make an order for costs against the public interest litigant. But it's not always clear, because sometimes what seems to be a public interest litigation might be brought by private landholders or interests. And so then you are saying, well, is this truly one brought in the public interest? Or if these, and sometimes in Australia, they can be very wealthy private landowners, or even, and such an irony, a trade competitor who brings the action and then says, well, when they're unsuccessful, well, it was brought in the public interest. So sometimes those cases aren't successful in having a no-cost order made. But I think the fact that it is discretionary as to whether the court does dispense with making a cost order can still have a chilling effect. So you're right that if there was a no-cost rule, then that would remove that chilling effect. But there's a limit to how far I think I can go through a court rule, because that's more a fundamental change in the sort of legal system. That might be a legislative change. So at the moment, I think I've gone as far as I can do by using the court rules. We are the only court in New South Wales which has an exception for public interest litigation. No other court has it. My feeling is that that's probably as far as I can, take it.
Thank you. Next question for Campbell. This is from James Curran, and James says, Scottish courts have often underplayed environmental offences and award small fines and punishments. Prosecutors have also been an obstacle in not taking cases forward. Would an environmental court have its own dedicated prosecutors? Campbell, is this something that you've thought about?
It's an interesting one, and I think it connects a couple of dots. Thanks, James, for that. I mean, going back to the period in the mid-noughties when I and colleagues were trying to focus the Crown Office on dedicated environmental fiscals, we were having interesting and diverse challenges from some of those in positions of power at the time, resisting the idea. And we were talking about sentencing guidelines and trying to help sheriffs come to more sensible decisions than a £300 fine for wiping out a kilometre of river. And there were a whole series of things that needed to be considered. At times, it has felt as if COPFS has been an impediment to progress. At times there has been interest. It's interesting reflecting on some comments we had before the meeting about looking for experienced litigants, experienced litigators, people in the House of Lords that might have expertise that would be of interest. And of course, Lord Mulholland, former Solicitor General, etc., was also the fiscal in North Lanarkshire. And had some experience of waste crime and all sorts of other issues. I'm perambulating there because I think there are a series of issues there's a series of issues that would need to be tackled. Dedicated prosecutors would seem to me to be a pretty valuable component of the system, and adequate training, adequate support in order to deliver that, I think would be an extremely good idea. I would like to see that professionalizing of the system, because failures at the point of sheriff and fiscal in the past have indeed been the reason that we've had some of the difficulties that we've had. So yeah, long-winded answer, but yes, I think it's a necessary part of a good system.
Not long-winded at all, and thank you very much, Campbell. Next question for Justice Preston, going back and forth. This is from Benji, who works at ERCS and is very involved in our Environment Court campaign. He asks if you could elaborate on some of the major cases you've been involved in, Justice Preston, and how having environmentally literate judges made a difference. I believe you also can sit with technical experts, so it would be interesting to hear about that and how that makes a difference to adjudication, please.
Yeah. Look, there's a number of decisions. I mentioned the Gloucester Resources case. That was one about climate change, and I think that truly understanding the, what is climate change, the causes of it and its consequences, assisted in resolving that case. But I think it also assisted in resolving the legal issues. I mean, a number of the legal issues that were raised have been raised in litigation all around the world. For example, issues about the scope of the emissions, scope 1, 2, and 3, understanding what direct and indirect emissions are, and then how they can be taken into account in the legal system. Understanding causation and what causal link did you need, and how that changes depending upon the legal question or context in which you're raising that issue. So, for example, for assessing the environmental impact, there's quite a low causal threshold. So that allows the sort of the rejection of the argument, which we see, it's only a drop in the ocean. Why should we worry about these emissions? Because no matter what you do in this case, it's never going to make a difference to the solving the global problem of climate change. Now that's come up in many litigations around the world, and it continues coming up. But I think having being environmentally literate, to take the phrase that the questioner used and I've used, assisted in understanding those legal questions. And I think that I've seen decisions made in New South Wales, which stands at odds with decisions made in the UK. So, for example, if you take the Heathrow third runway case, and you look at from the High Court, the Divisional Court, through to the Court of Appeal to the Supreme Court, and the different interpretations of Section 5.8 of the Planning Act in the UK about government policy, what does it mean? And that's a legal question, but I think that we came to quite a different answer in New South Wales in the Land Environment Court because of having that, being environmentally literate. We actually understood how policy works in the climate change context. And so I think, rather regressive interpretation of the Supreme Court was traditional, it was conservative, but it wasn't in tune with what is modern environmental governance and regulation. So that would be seeing the difference. Look, I've been in many biodiversity cases where I used to teach for 20 years biodiversity law at postgraduate level at university. I have training in biodiversity. So I think having that literacy allowed me to decide those cases. So I won't go into the number, but both in the civil and criminal context, where I've examined what biodiversity is, its values, its impacts, what measures we need to do about bio-offsetting and the sham that it often is. I think having that literacy assisted. And I'll finish with this point about ecologically sustainable development, all those principles, understanding what is the polluter pays principle, what's the precautionary principle, what does it mean to have intergenerational or intertemporal equity. I think having a good understanding of that really assists in deciding the cases, both the legal and factual issues.
Thank you. We're finishing the question session in 5 minutes. So I think just last one, which is from Hannah Maneagle. And we'll open this question to both of you. Campbell, I see that I think you answered it in the chat and then the answers disappeared. It starts as a question for Brian, Justice Preston. How far does the scope of your jurisdiction go with respect to planning law cases? And Hannah explains that our planning system has a fragmented process for challenging planning decisions, which she then goes on to explain that there's no one-stop shop for that. And Campbell, would you like to start with that, please?
Yeah, I touched on the DPA just in my list of elements. I think there is a likely challenge around establishing a Scottish Environment Court to just look at its edges and what would or would not be contained within it in terms of its remit. But it seems to me that planning cases are amongst the most egregious in many situations. I mean, there are breaches of higher law, particularly inherited European law over water, air, waste, etc., which are very important that they be at the centre of the mission of a court. But it seems to me that DPA territory should be included, not least because, again, the asymmetry around the power of a developer versus a local group or affected individuals at the local level can be massive, and cost, etc., available, the deep pockets of the developer. So, and a series of pretty controversial decisions by reporters also. Therefore, it makes it all the more important that territory be, in my view, included. It would add a significant component to the remit of the court, and that needs to be borne in mind. But my personal view is that if you're going to do this, you should do it properly, and you should do it for the areas that are of concern to the citizenry and are of importance to the environment, and that would mean that planning has to be included.
Thank you, Campbell. Justice Preston, any comments on the planning jurisdiction of your court?
Yep. We have a very extensive planning jurisdiction, so the best way to explain it would be we are both the planning inspectorate system in the UK, as well as the planning court or the High Court for doing judicial review. So we do both the merits review and the judicial review. But we also have extensive jurisdiction. There is not an environmental or planning law that our court doesn't administer. So there's about 50 different courts. So we cover everything. And that means that there is a synergy, that we look at the dispute from all different aspects and are able to resolve it. And that builds up the expertise. Because we can see it from different perspectives. So it's not fragmented. I think that's the real benefit of the Land and Environment Court, is that it has the most comprehensive jurisdiction of any environmental court in the world, and including Australia. And I think that really is critical. It's one of my, desirable dozen, that you've got to have this comprehensive jurisdiction to do it.
I'll remember that, the desirable dozen. Okay, I think we're going to have to leave it there. Thanks very much to everyone who's asked questions. We went from a complete absence of questions to a glut that I couldn't deal with. So thank you for all of those, and sorry to those whose questions we haven't got through. This is one of a series of Lunchtime 101 events. The next one that we're doing is going to be on the 4th of June at 1 o'clock, and it's called Protecting Our Woodlands. If you're interested in coming along to that, you can find details on how to sign up to it on our website. And if you're interested in our work and on our campaign for an environment court, lots of details on our website, lots of reports and briefings. You can sign up to our newsletter or become a member of ERCS. Both of those are free if you're interested in this subject. And I'll just finish up by saying thanks to all of those who've come along and listened to this. I hope that you found it useful, and thank you very much to Justice Preston and Campbell for coming along and giving us their contributions, which were both great. So thank you, everyone.